Thank you very much, Sylvia Albert, for joining us on Objections. Let's just start things off very broadly. There are many efforts all across the country to restrict voting, and you have been monitoring quite a few of them for Common Cause. Can you give us a broad overview of what's going on?
Well, what we saw this year, or I should say what we saw last year in 2020, was record turnout, which was assisted by record access to various types of voting opportunities. That includes vote by mail, that includes early voting, that includes voting in person and longer hours and drop boxes and all sorts of avenues for people to cast their ballot. This response that we're seeing right now by legislators in the state is them saying, oops, wait, we didn't actually want you to vote.
And so what's happening across the country? Just how many, we're seeing state houses trying to pass various different measures. Give us a sense of scale. How many state houses are trying to restrict the access to the ballot, and what are they trying to do in order to accomplish that?
Well, there are hundreds of bills across the country. I would say at least half of the states have some voter suppressive bills there. Of course, just like any other legislative session, people present bills that they know are going nowhere, right? They want to be able to say to their constituency that they sponsored X bill or Y bill. But what we are seeing, and what we're seeing being done successfully in some states, is limiting access to the ballot. And what that means is all of those things that I just mentioned that enabled people to vote in record numbers last year, it's taking them away or eroding them. So, for example, in Arizona, there is an attempt to undermine vote by mail, not by eliminating vote by mail, which Arizona has used with over 70% of its citizens since before 2020, but to say that if you want to use vote by mail, you have to include a photocopy of your ID. I don't know about you, I don't have a copy machine in my apartment, and that is a barrier for people. So there are bills in other states to eliminate drop boxes, which was a great avenue for people to return their ballot, especially in the midst of all the controversy around the Postal Service. There are bills to revoke no excuse absentee ballots. So you would have to have an excuse. There is a bill in Texas that would demand that people with disabilities prove their disability in order to get an absentee ballot. So really just any avenue from which, more voters were able to access, democracy is being attacked with these bills.
And what do you think? Obviously, after the 2020 election, there were numerous efforts to try to overturn the results, and handled by former President Trump and his allies, and very often just blatantly trying to shelve the results in a number of states. All of those efforts they failed, and they were swatted away by the courts and found meritless. Do you think that gave a sense of security by many in the country that the courts would be a safeguard against this? And do you think to what extent do you think that the courts will protect against some of the measures that we're seeing in state houses across the country?
Unfortunately, I don't think the courts will be very protective of these discriminatory and suppressive laws. Or I should say, these courts will not protect our voters from discriminatory and suppressive laws. What we've seen is over the last 10 years, especially since a Shelby County decision in 2013 with the Supreme Court, is the Supreme Court more and more saying, well, as long as you have access to voting in some way, shape, or form, and unless you can prove absolutely with certainty that discrimination was the only purpose in passing this law, then it's okay. So it is not likely that the Supreme Court will actually take on these laws. We will attempt. Obviously, we think that the Supreme Court's interpretation of the Voting Rights Act is incorrect, and there will be litigation, but I don't find, I'm not very confident that the courts will protect us. And as to what the courts did last year, what's really, I mean, to me, what's frightening is the idea that if we saw last year, if last year was a combination of last year and 2020, I think we'd be in a whole different situation. What we had last year was overwhelmingly no evidence of anything wrong, and overwhelmingly courts from, judges appointed by Democrats, Republicans, by President Trump himself, saying, if you have any evidence, bring it to me. And there was none. And that's the reason it got, as you say, these cases all got swatted away. And because the division between the two candidates actually was a lot, right? It was tens of thousands of ballots. President Biden won the same number of electoral votes that President Trump won in 2016. But if we had been at 537 votes in Florida in 2020, I am not confident that we would be in this situation right now. I'm not confident that we would be here, speaking 50 days after the inauguration of the person who clearly won the election. I think it could have been very frightening.
And as we talk today, the intelligence community released a report finding yet again there was no foreign intrusion into U.S. election infrastructure, that this was a safe election, in the words of a former Trump official. It was, Chris Krebs called, the most secure election in U.S. history. And yet, in what ways has the narrative surrounding the 2020 election been used to justify some of the measures we're seeing all across the country, despite the courts, Trump officials, the intelligence community, all saying there's no there on these voter fraud allegations?
Well, first of all, President Trump used the last year to undermine the election process, right? Every time he was asked about the election, he basically said, if I lost, then the election was a fraud. The election hadn't happened yet. So he used his pulpit to undermine people's confidence even before the election happened. And then obviously when the election happened, he and fellow Republicans, state legislatures, congressmen, senators, continued to undermine people's confidence. And then after spending, 6 months telling people there was something wrong with the election, they are now using that as a smokescreen to say, well, people aren't confident in the election results, so we need to suppress the vote. And really, it's they've created this situation and now are using it as an excuse to enact voter suppression. And I say an excuse because it's been clearly the goal of this party for maybe the last 15 years. The Voting Rights Act was reauthorized in 2006, 98-0. No Republican voted against it. There are 10 Republican senators in Congress who voted for it that are still there. But yet now the Voting Rights Act isn't good enough. Now the Voting Rights Act is not something that the Republican Party believes in.
And as you mentioned, the Voting Rights Act was gutted quite considerably with the Shelby County decision, which the Supreme Court ruled on quite a time ago. The Supreme Court has another case that I want to talk about soon, was heard earlier this month, the Brnovich case. But can you unpack just what the decision in Shelby County meant for voting rights in the United States?
Sure. So when the Voting Rights Act was passed, it included a provision called preclearance. And what that provision said was basically, if you have a history of discriminatory policies and voter suppression in your community, and you want to make any changes to election law, you have to get it pre-cleared by the Department of Justice. So that meant, you couldn't just unilaterally make changes that would have a negative effect on voters, and then later, the Department of Justice would litigate and try to undo it. Instead, it was, you have to get the Department of Justice's approval to go forward. So a number of things that have been implemented since that decision were previously not given approval by the Department of Justice. So basically, the Shelby County decision did away with pre-clearance and said that these jurisdictions no longer had to get the Department of Justice's approval. And what we saw immediately was voter ID laws, revoking of early vote, shutting down polling locations, all things that the Department of Justice had said they could not do, and had said that had a discriminatory impact.
And what was the chief's justification at the time? What did he? How did he posit it?
Basically, racism isn't as bad as it used to be, and we don't have the same problems that we used to have. But is kind of the way he phrased it. Justice Ginsburg had a great dissent, which I cannot say her exact language, but it was basically, you don't throw away the umbrella just because you're dry, right? Like, you're dry because you have the umbrella. Right. So we have a better system, or we had a better system in 2013 that had less discriminatory impact and less harm to voters of color because of the Voting Rights Act. And so by eliminating that protection, we are now, and you can see this, we are now devolving into more and more voter suppressive laws being passed.
To extend that RBG metaphor or analogy, would you say we're facing a storm of
oh, absolutely. Yes. Right. Yes, we're about to be soaked to the bone.
So that brings us to Brnovich. That was brought before the Supreme Court earlier this month. It looks like the conservative majority is tilting in one way, with the liberal wing very outvoted. If that's the case, what is at stake?
Well, as I said, one section of the Voting Rights Act was undermined by Shelby County in 2013. That's Section 5. This decision would or could undermine Section 2, which is really the last bit of the Voting Rights Act that still has teeth. So this is the part of the Voting Rights Act that says if you can show discriminatory intent and discriminatory effect, then you've got the silver bullet. Like, you've shown what you need to stop bad bills that have negative effect on communities from going forward. And if you take that away, then we have no way whatsoever to stop, rampant, obvious, flagrant, racist voter suppression laws.
So what can be done about it? There's obviously movement happening on Capitol Hill right now. There's some questions whether it can be passed. What are some of the things that you're pushing for, whether it's public attention or the issues that you're advocating at Common Cause to counteract this trend that you're seeing?
So we absolutely are in favor of both HR 1 and HR 4. So HR 1, the For the People Act, which was passed by the House, would establish basically a floor for voting rights around the country. Right now, your voting rights depend on your zip code. So I live in Washington, D.C., so I can vote absentee, I can vote early, I can vote by mail. If you live in Indiana, you can't do those things, right? So the For the People Act basically says, here's the floor. Everybody in America should be able to vote by mail. Everybody in America should be able to vote early. Everybody in America should, have access to automatic voter registration, or a number of other provisions. That we think will be a good way to protect against these types of laws, which could not go below the floor, right? There's no ceiling. You can feel free to give people as many rights as you want, but you can't go below this point. And HR 4, the John Lewis Voting Rights Act, would reinstate the Section 5 of the Voting Rights Act. It would basically kind of, show Justice Roberts and the court, here are all the reasons why racism is still here in America. And it updates the formula, which is part of the reason that Justice Roberts was unhappy with it. He said, it's not, racism isn't the same, so you can't use the same formula that you used in 1965 to determine which jurisdictions have to get pre-approval. So this would update the formula, recognizing that there have been some changes since 1965, but that racist discrimination is still here in America. So those two bills, I think, are really important. And I think talking about them is really important. And talking about the voter suppression efforts happening in the states is very important. Often election laws go unnoticed as they pass in off years. And, people pay attention to elections often the same way they pay attention to the Olympics, right? Nobody knows anything about Michael Phelps, but, every 4 years, everybody's really excited to watch him and knows exactly how many gold medals he needs to break records. So I think shining a light on the actions of these legislatures and making it clear to their constituents exactly what they are doing so that they cannot hide in the future.
On a practical level, do you think that either of these pieces of legislation will pass if the filibuster still exists in the Senate?
I think that it's possible with filibuster reform. I am not the lobbyist in our office. We have other people who do that. But I think this is a long-term struggle. I think this is not a 1 month or 2 month fight. This is a fight that might take all year, but it is a fight that we need to win.
Going to what you were saying before about people following every 4 years, do you think that the fact that the post-election cycle brought us lawsuits that were sometimes quite bizarre and so drastic in what they were requesting and races that were not close, has sort of inured the public to the kind of more insidious and professionalized versions of the kind of things that you described fall under the radar?
Well, it depends on which part of the public you're talking about, right? Because something like 30% of Republicans still believe that the election was stolen. So this part of the population has just doubled down that everything was wrong, every judge was wrong, it is a wide conspiracy. Yes, I think it has, and just like I think a lot of the Trump administration actions in the past 4 years have activated people's activism and need to be involved in grassroots actions. People are paying attention to things that they took for granted previously.
Mm. So in that sense, it's had the opposite effect. It's sensitized people because they saw a drastic manifestation of it.
Yes, absolutely. I think, I like to think that these voter suppression bills are going to have a bounce back effect, right? I hope that if a voter suppression bill passes in your state, that you make that much more of an effort to vote and to vote for democratic ideals and to vote so that you are represented. That's my hope. And, the advocacy groups will be doing our best to see that happen.
And you've been monitoring these nationally. What
Yes.
is the most outlandish or egregious measure that you've seen proposed in a state house?
Well, it sort of varies because the place that each state is starting is different, right? So Texas has abhorrent laws regarding everything regarding elections. Voter registration is incredibly difficult in Texas. There's a lot of difficulty in voting in Texas. And a new bill in Texas would require persons with disabilities to prove their disability in order to get a absentee ballot, which is ridiculous and I don't think legal, but we'll see what happens. So Texas is starting from so far down. But then, you have a state like Georgia, where in 2005, a Republican-led legislature passed no excuse vote by mail. And now there's an attempt to overturn that and go back to a system where you have to have an excuse to vote by mail. Why? Well, because people came out and voted in this election, but didn't vote for these legislatures. And what's really, it is, I find ironic that Republicans were successful up and down the ticket, except regarding President Trump, but they have still kind of doubled down on the idea that voter turnout means that they lose. This is sort of a theory that's been floating around in the ether for a long time, that if more people turn out, Democrats will win. We saw record turnout this past year, and we saw it from people on both sides of the aisle. But it's still, kind of, that's still being taken as gospel, and legislators are moving forward with that intention.
Thank you very much for joining, Sylvia, and keep us posted about everything that's going on.
Thank you for having me.